Without further ado, let's bring in our guest who is standing by. Joining us this hour, national trial attorney Michael Jaafar, pro-prosecution when it comes to this. He makes no bones about it. Let me ask you this about the Commonwealth's case, because we expect in these opening statements that they are going to weave in some interviews that Karen Read has given between the first trial and this second trial that's about to happen. She's talked about finding John's body and seeing some glass on his face that she picked off. She's also said that I called my attorney and I said, what if I bumped him? Would I still be liable? What if I possibly did that? What do you think the prosecution will use, and how do you think they will weave it in to be effective?
They're going to take advantage of the fact that the time between the first trial and the second trial gave Karen Read enough rope to hang herself. They're going to bring in all the things that you just said. They're also going to bring in the fact that she was interviewed saying, hey, I was drunk that night. I'm not as good when I'm drunk as when I'm not drunk. I can't remember things as good as I did. This woman is a complete narcissist, right? And when you give narcissists a year to talk in public, they are going to hang themselves, and that's exactly what she did. They're going to bring in her statements, because at the end of the day, her statements are going to break down the whole entire allure of this conspiracy and conspiracy this and conspiracy that. They're going to have a ton of fun, in addition to bringing in different experts. But all of her statements that she made, listen, I hope they bring in the statement she made in September where she said she likened the people, protesting in her favor with Vietnam War protesters, which maybe I think that makes her Ho Chi Minh, right? So they're going to bring in a bunch of stuff that she said, and it's going to absolutely tell the jury a story that they didn't see in the first trial. In the first trial, she had a bunch of public statements, and the public statements were not backed by anything, as we saw in the first case, with any kind of a hard evidence, right? But now, since the first case, she has made even more and more statements, and it's going to be a ton of fun for me to watch. I'm really excited for this.
I was just going to ask about that, because she did make statements. I hit him, or did I hit him? The jury heard these kind of statements from her, but to Michael's point, not on the record.
Right. The jury was picked earlier this week. You have the Easter weekend coming up. So Uncle John got picked to the Karen Read case, and the family's over for Easter. How much faith do you have that this jury is not on a crash course of all Karen Read going into the openings?
I'm so happy you asked that. I hope that we as a society of jurists look at this case at the inflection point that I look at it as, which is there's no more such thing as jury sequestration. Every single one of those jurors knows everything about this case on day one. They know everything. They've engorged themselves with this information. Why wouldn't they? It's in their backyard. I know people from other countries who've asked me about this case. Definitely people who see the crowds and see the anger and the raw emotion in that community. They know everything about this case. So to answer your question, they're going to be like heroes. Like, they're going to have people over for the barbecue. Some of them are going to be pro Karen Read. Some of them are going to be against Karen Read or pro John O'Keefe. And they're going to be rooting for their friend and family member that, hey, make sure you get it right. I think that's why Judge Beverly Cannoni impaneled more jurors than they typically do. In this case, they usually do 16. She put 18 because I think she knows her customer. She knows she's probably going to have to disqualify more than one or two jurors. She knows that. Right? This judge has done it right the whole entire time because she knows her customer. She knows who she's dealing with. And so I think, to your point, Ted, I think a lot of people at barbecues this weekend who are going to be on the jury, hey, did you know that our cousin is on the jury or our high school friend is on the jury? Hey, why don't you come talk to him right now? Hey, you know what? You got to get it right. She did it or she didn't do it. So it's going to be a challenge. But this should be the inflection point for us to say that, man, jury sequestration, it's just different in 2025 than it was in 1925.
We don't know about those jurors, but we know our Court TV team. They are there in Dedham, Massachusetts. They are prepping for what is to come next week. Michael Jaafar, stand by. We do have to get to a break. Let's bring in our national trial attorney, Michael Jaafar, who is watching this along, no doubt reacted to this yesterday. We were all so heartbroken to hear what was happening on this college campus. School shooting cases are the worst. It takes me back, Michael, to sitting through the Parkland school shooting case, where in that case as well, we had a shooter who survived, which is not always the case when it's a school shooting incident like this one. This is a alleged shooter who is injured, but is going to have to face charges. Tell me about what the process is going to look like and the nuances when you have a case like this one.
This is going to be extremely difficult, and I'll tell you why. This is the first of its kind for this reason. We sat through the Crumbly fiasco, and it was the first time in American history where the parents of the shooter were charged because of the fact that the child used one of their guns, right? What happens here? In the state of Florida right now, there is so much tension in the decision-making process because they have to ask themselves, are we going to charge his mom? She was a sheriff's deputy. They came out ahead of it. The press conference, her superior came out and said she had, I think, 18, 19 years of flawless service to the state. What do? Do they charge her? Are they going to have a double standard? I'm not taking a position on this. I'm just telling you that this is going to be the most difficult thing that they're going to have to discuss and debate is what do they do? Because this is not just like a typical school shooting. This is something that is on its own level. They don't know. This is going to be something, I would hate to be in that room. The tension is palpable. But at the end of the day, they're going to have to proceed against the kid. But they have to decide what are they going to do with the mom. I don't know. That's going to be tough. This is the first time this has
Does the
ever
fact,
happened.
Michael, that he is 20 years old, Crumbly was in the house living there and was a minor. At what point does this parental sort of guidance stop? I mean, the kid's he's not only 18, he's 20 years old.
Great question. That's a factor. That's a big factor. And I'm glad you pointed that out. It's a massive factor, right? But it's not like a total absolution of, there's no guilt because he lived with her. He had access to her gun and he took her gun. I'm not taking a position and saying they should go after her. There are some people that think that they should have never went after the Crumblies. Some people think they should have went after the Crumblies. Again, that's why this is a unique case on its own. Going after the kid and putting him in jail for the rest of his life, that's a fait accompli. If he's guilty, he's innocent until proven guilty. If he's proven guilty of this, that's not even a tough one. But what you do with the sheriff's deputy mom, at the end of the day, is there negligence? Is there carelessness? These are just the things that have to be debated. And as a society, this is the first time any state has had to entertain this.
Michael, real quick before we have to shift gears, do you think that this stays in Leon County, where we have the sheriff's office is part of the family of this person, FSU, picking a jury there? I mean, what do you think?
That is such a great question. I didn't think about it until you said it. That is such a fantastic question. It's so complicated. I don't think it should. It's too close because the double standard, you're going to be accused of a double standard if you don't charge this sheriff's deputy. They came out ahead of it in the press conference and they immediately said I was thinking, why are they talking about how much of a service record she has? And I clicked. I was like, oh, they're worried. They're worried that she's going to be charged and their whole entire department is going to be charged. And by the way, there's going to be civil cases against the state by the parents and by the family. They're going to sue the state. That's going to happen. There's going to be civil cases against the state for years. And so their lawyers are telling them, you may have to charge her, or if you don't charge her, you're damned if you do, damned if you don't. That's a great question, Julia. I think they should recuse themselves. I think it should go to another county.
Yeah, we will wait and see. He still hasn't made his first court appearance as of yet. That will be upcoming, and this will move down the road, the legal system, and we'll be following it all. Let's turn our attention to New York, where a judge in the judge in the Sean Diddy Combs sex trafficking case has denied the defense motion to delay the trial.
Yeah, Combs' defense team, they have been asking for 2 more months to get ready for this trial, to prepare their defense. They said in a letter to the judge that prosecutors have been slow to turn over evidence for review. We know the separate indictments, the superseding indictments have grabbed headlines that have been in the last 30 to 60 days, a second and a third. So the judge has now denied that motion. So it appears this trial is still going to go forward as of May 5th with jury selection.
Michael, denying that, why not just give the defense a couple weeks?
Yeah, I don't like it. I don't like it at all. I don't know why they would deny it. I mean, it's a very reasonable request. At the end of the day, this case, there's gravity, there's levels to this stuff, right? There are many people who are charged with what he's charged with, but nobody knows their name, and so their trials are very small, and the resources that the government devotes to prosecuting those people are on a fraction of what they're devoting to prosecute Sean Combs. So people can't think, well, he's rich, he's got attorneys, he can be rich. No, not really. The government is always going to have more resources than you when you're the defendant. There's nobody wealthy enough, more powerful enough to have more resources or as many resources as the government has. when they're prosecuting you, we know that they had a sting operation. They were looking at this guy for months, potentially years. So why an extra couple of weeks, even 2 months? I think it's just ridiculous. I think it's absurd. I think it taints the process. I think they should have given him more time. I was a little bit puzzled by it, to be frank with you.
So let's add in the nuance of potentially a speedy trial waiver that hasn't happened for Diddy. I noticed in the docket some mention of speedy trial and that there were some months that were excluded from the ticking of the clock, but I don't think he's waived his right to a speedy trial, meaning if the prosecution can't bring the case against him in that time period, then he could get out on bond. But they're going forward to the trial. The defense is the one that wants this 2-month delay. Can they do that and not waive speedy trial?
They can do that without waiving the speedy trial. They can absolutely do that because a speedy trial, the definition of speedy trial isn't like a hard cutoff, but they can absolutely do that. At the end of the day, the two things are separate. Now, if they ask for a 2-year delay, then the argument by the prosecution would be, hey, you waived your right to a speedy trial because we wanted to try you in May and you wanted us to try you in 2027, right? So there's gravity, but I don't think they would have, it's a waiver to ask for an extra 2 to 8 weeks.
The video that we all saw of Sean Combs and Cassie, the elevator, the hotel, the horror, you take that out of the equation, would we be here?
I don't think so. Well, here's the thing. I remember about a year and a half ago when there was a sting operation and they raided his house and one of his former colleagues flipped, and then there was the allegation of drugs and being brought in from other countries. But the elevator video obviously is an inflammatory video. So, maybe we wouldn't be here if it wasn't for that. I know that they were after him for a long time. They just picked him. They picked him and they said, we're going to go after him. And there's a lot there. And he gave them a lot there. But that video is grotesque. And the civil suit where she sued him and he settled with her. And he was just brazen in his conduct before the video came out, after the video came out. I think that video maybe probably 80% of the reason why he's not out on bond and why we're here. But there were other things. He dug his own grave in many ways.
We will, of course, keep you updated on what happens in that New York courtroom today where they have that hearing. Michael Jaafar, thank you for all of your analysis this hour.